As I guess you can tell, we are skipping chapters 19 and 20, at least for the time being, though we did have one person who suggested that they would like to know what the contents are of chapter 19. Of course, you're always free to read any chapters that we don't actually go over in a lecture format. But chapter 21, which gets us back to the UCC, which is what we've been doing. You'll recall that negotiable instruments was Article 3 of the Uniform Commercial Code, that sales are Article 2, and that leases are Article 2A. This is security interests and creditors' rights, principally, again, under the Uniform Commercial Code. This is Uniform Commercial Code Article 9. Which, to my knowledge, has been adopted in every state in the country. Unlike Article 2, which has not been adopted in the state of Louisiana. It's important to understand what a security interest is. First and foremost, let me give you a couple of examples, just so if it doesn't seem instantly familiar with you, maybe it will be after this. A mortgage is a security interest, which means basically you have borrowed money against, generally speaking, a piece of real estate, although there are such things as chattel mortgages, which means a mortgage on personal property. And if you fail to make an installment payment on that mortgage when it is due, you go into default, and the creditor who had loaned you the money and taken the security interest in the form of a mortgage has the ability to foreclose, in which case they will take the property away from you. Very similar to that, and this definitely does fall under the UCC. You'll recall that the UCC does not apply to real estate, but only applies to goods. If you purchase a car, borrowing the money in order to purchase the car, you are going to have a security interest that is granted to your creditor. And once again, if you don't make the payment, they're going to repossess the collateral, which would be your vehicle. They'll come and hook it and take it away. So that gives you a nutshell as to what a security interest is, and hopefully that will make the rest of this chapter make a little more sense than it might have. And here are the learning objectives, which I'll remind you may or may not have something to do with a subsequent quiz. First of all, what is required to create a security interest? Second, how can a security interest extend to a debtor's newly acquired inventory? Third, if two parties have perfected security interests in the debtor's collateral, which party has priority on default? Fourth, when is a creditor required to sell or otherwise dispose of the repossessed collateral? And finally, what is a suretyship and how does it differ from a guarantee? Okay, creating and perfecting a security interest. A secured transaction is any transaction in which the payment of a debt is guaranteed or secured by personal property owned by the debtor or in which the debtor has a legal interest. Notice this is a definition for purposes of the Uniform Commercial Code. Article 9 of the Uniform Commercial Code governs secured transactions in personal property, which includes accounts, agricultural liens, chattel paper, which are documents or records evidencing a debt secured by personal property, fixtures, which are certain property that is attached to land, and intangible property, such as negotiable instruments and patents. Here are some key definitions, and recall because the UCC is a legislative code, these definitions are incorporated into the code. And so you can go and look them up in the statutes and read the definition that the various state legislatures have provided, which are used throughout the different articles of the UCC. So a default is a failure to pay the debt as promised. A secured party is a creditor who has a security interest in the debtor's collateral, including a seller, a lender, a cosigner, or a buyer of accounts or chattel paper. A debtor under Article 9 of the UCC is any party who owes payment or performance of a secured obligation. You will find, when we get to it in the next chapter, bankruptcies, that debtor has a particular meaning there as well, which has been established by Congress, since bankruptcy is federal law, while the Uniform Commercial Code is state law. And the definition is quite different. More definitions. A security interest is any interest in personal property or fixtures that secures payment or performance of an obligation. A security agreement is any agreement that creates or provides for a security interest between the debtor and a secured party. Collateral under Article 9 of the UCC is the tangible or intangible property that is subject to a security interest. So, to the extent that you have a chattel mortgage, which covers something like fixtures, which are otherwise attached to real property and ordinarily would be considered real property, but are allowed to be considered as personal property for purposes of the Uniform Commercial Code, those fixtures would be collateral. If you went out and you bought a car on time, your car is collateral. Finally, a financing statement. This is the UCC-1 form, and every state uses this form. You fill the form out. This is particular interest to those of you who wind up in banking. In order to make sure that you have perfected your security interest and that the bank is protected on a loan that you've made to the typical ne'er-do-well debtor, you have to follow the statutory form, and you have to include the information that is required by the form. It's a document that is filed by a secured creditor with the appropriate official. In the case of Florida, it's with the Secretary of State's office, and in most states, it's with the Secretary of State's office, which gives notice to the public of the creditor's security interest and collateral belonging to the debtor named in the statement. Generally speaking, unlike mortgages, which are an interest in real property, not covered by the UCC, which are recorded in the county where the real estate is located, financing statements are going to be recorded in one central location in a state. And that is for ease of commerce, in order to be able to discover whether or not inventory or equipment or something else has been collateralized and is subject to a financing statement in order to be security for a loan. Okay, so what are the requirements to create a security interest? A creditor has two main concerns. If a debtor defaults, which is, as we saw from the definition, fails to pay the debt when it's due as promised, first of all, the creditor is concerned whether the debt can be satisfied through the possession and typically the sale of the collateral. And secondly, the debtor is concerned whether the creditor will have priority over any other creditors or buyers who may have rights in the same collateral. These two concerns are met through the creation and perfection of a security interest. There's three requirements that have to be met for a creditor to have an enforceable security interest. Unless the creditor has possession of the collateral, there must be a written or authenticated security agreement that clearly describes the collateral subject to the security interest and is signed or authenticated by the debtor. So, for example, if you have stock, and that stock is represented by a certificate, and it's going to become the collateral for a loan, it's a very easy matter to simply hand the stock certificate over to the creditor, and by putting themselves in possession of it, they've gone ahead and they've perfected their security interest in the collateral, which is the stock that you've handed to them. But if you're talking about a security interest in inventory or equipment or anything else that the debtor is continuing to use in their day-to-day operations as a business, you're going to have to do more than that. So in order to do that, you're going to have to create a writing, which is a security agreement. And that writing is going to have to be authenticated by the debtor. And essentially, authenticate just means that they sign it or execute it or adopt any symbol on an electronic record that verifies the intent to adopt or accept the record. So that's the first requirement. The second requirement is that the secured party must give something of value to the debtor. Typically, it's going to be money, because typically it's going to be a loan. And finally, the debtor must have rights in the collateral. And typically, it's going to be that the debtor owns the collateral, but they don't necessarily have to own it outright. So an easier example than the UCC would be, say, real estate. If you had a remainder interest in real estate, not the present possession of the real estate, but you were going to, it was going to belong to you when someone else who had a life estate died. You could collateralize that. Or if you had a life estate, and of course upon your death we had nothing else left, you could collateralize that as well. So once you've met all three of those requirements, the creditor's rights are said to have attached to the collateral. Attachment is what gives the creditor an enforceable security interest in the collateral. Okay, not for the first time. I've sort of gotten ahead of ourselves here. Written or authenticated security agreement. You authenticate by signing or executing or adopting any symbol on an electronic record that verifies the intent to adopt or accept the record. Secured party must give value, and the debtor must have rights in the collateral. And this is one of the, by now, you've grown to accept as being a typical kind of illustration from Chapter 21 of the book, showing that the secured party has a security interest in the collateral, the debtor has property rights in the collateral, and that the security agreement is giving the secured party certain rights to the collateral in the event that the debtor defaults upon their obligations. Please take a moment to read this slide and perform the action that it is requiring of you. Thank you very much, and you may resume. Okay, so attachment is great as far as the creditor is concerned with the debtor, but it doesn't do anything to protect the creditor from claims of other parties in and of itself. That requires something called perfection. And in order to perfect the security interest, you have to go through a legal process by which the secured party protects its security interest in the collateral against the claims of third parties who may look to the same collateral to satisfy the debtor's obligations in them. So, again, as I said before, in the case of real estate, that is going to be accomplished in the case of purchase funded security interests, for example, by the recording in a county of a mortgage. In the case of the Uniform Commercial Code, for every type of collateral, the secured party may perfect their security interests in one or more of the following ways. As I mentioned before, you can file a UCC 1, which is a financing statement, or some similar document if it's not, if for some reason it doesn't happen to be called that in your state, although I'm unaware of any state where they don't call it a UCC 1, which indicates the interest in the collateral, or by taking possession of the collateral. As I said before, you can take physical possession of the collateral in order to perfect your security interest, and then no other creditor is going to be able to say they have superior rights because you, the creditor who has actually got physical possession of the collateral, have physical possession of it. Or you can create something that's called an automatically perfected security interest. So in the case of perfection by filing, there are a certain number of things you've got to have. The financing statement is going to give public notice to third parties of the secured party's security interests. So it obviously has to have the names of the debtor, because otherwise how would you be able to check public record and determine that the debtor had given up their rights in this collateral to a secured party? It's got to have the name of the secured party as well. And it has to identify the collateral covered by the financing statement. And that requires a description. And the description of the collateral is something that banks screw up all the time by not having a complete enough description. I mean, they'll have a description that will say something like equipment, but it won't bother to specify the equipment. And the equipment may consist of things that are, $100,000 plus machines. Obviously, in order to make sure that you are securing the interest in the collateral, you need to have an accurate description. If it's something that has a serial number, you need to have the serial number. If it's something that has, and a model number and whatever, and a name of what the thing is. In terms of certain kinds of property, it may be enough to have a generic description, simply because quantities of inventory may fluctuate. But that way you're at least putting the world on notice that the inventory that is being handled by a retailer, say, is subject to your security interests. You have to file where it tells you to file. Again, in Florida, that happens to be with the Secretary of State's office, and they designate where that is. And it has to be done nowadays online. And then the consequences of not filing properly are fairly severe. I mean, obviously, if you haven't done it correctly, if you haven't described the collateral correctly, and somebody else comes along after you and does properly describe the collateral, they're going to be the ones who have perfected their security interests. Even though it's done after your attempt at perfecting the security interests, theirs will be successful. Yours won't be. You'll lose as a creditor under those circumstances. So this is something to take very seriously, particularly those of you who are going to wind up in banking, particularly if you wind up as bank officers, particularly if you wind up financing transactions, which, a fair number of you might be if the economy ever comes back again. Perfection without filing. And I'll give you a tiny bit of a history lesson here. Um, a long time ago, before the Uniform Commercial Code, the only way that a business was able to borrow money and give a security interest in its inventory was literally to have the creditor take the inventory and lock it behind a gate in the store, and for the creditor to release each individual item of inventory to the retailer as it got paid for when somebody came in and purchased it. And literally the retailer would go over, pay a certain percentage of the total debt, and take possession of the piece of inventory in order to pass it on to the purchaser. The UCC has somewhat simplified that process by no longer requiring that. Okay, so perfection without filing includes perfection by possession, as we've discussed before. You go ahead and you pledge certain collateral as security for a debt. You transfer the collateral over to the creditor's possession. They return it when the debt is paid. Perfection by attachment. Purchase money security interest in consumer goods. That's also known as a PMSI. Other than talking about motor vehicles or fixtures. And in the case of certain states like Florida, where we have titles to boats, it wouldn't include boats. But ordinarily, a PMSI in consumer goods automatically perfects at the time of sale. So if you go to Rooms to Go, purchase a room full of furniture, buying goods on credit, then it automatically creates a purchase money security interest in those goods. That thus makes those goods into collateral. Now, typically, you're going to find that folks who do go ahead and sell their personal possessions of that nature are not going to bother to inform the people that buy those goods that there is a purchase money security interest in them. But in theory, they remain subject to it even if the consumer sells it out from under the interest that the creditor still has. There are exceptions to the rule of automatic perfection. Obvious ones are that certain goods such as automobiles, trailers, boats, mobile homes, farm tractors, etc., have title requirements in many states. And because they do, in order to effectively create security interest in it, you have to record a lien somehow either on the title or associated with the title. Although lately, now that most states have been changing from paper title system over to an electronic title system, how you do that has become different. And a purchase money security interest in non-consumer goods, such as a business's inventory or livestock, is not going to be automatically perfected. And finally, as a general rule, financing statements are effective for 5 years from the date that they're filed. It is possible, however, either within 6 months before the expiration of a financing statement to extend the original financing statement for another 5 years, as long as the creditor takes that action and records a continuation statement. So, in addition to covering collateral that already exists, that's already in the debtor's possession at the time that a loan is made, um, a security interest can cover other types of property, including proceeds. Money or other valuable assets that are received when the debtor sells or otherwise disposes of the collateral. Uh, for example, a check that's received by the debtor after they sell part of their inventory. You can also acquire a security interest in after acquired property. That's property that fits the security agreement's collateral description that the debtor acquires after executing the security agreement. So for example, if your collateral did not include inventory in the first place, and the debtor subsequently acquires additional inventory, you're not going to have a security interest in that after acquired inventory either, because you didn't have one in the original inventory. But if you do have one in inventory and you say, and in after acquired inventory, then that property will be subject to the security interest when the replacement inventory is obtained by the debtor. And so obviously this makes a lot of sense. You're talking about a loan that's going to be for 5 or 10 years potentially. You don't want to only have a security interest in the original inventory, because hopefully the business is going to sell all of that inventory in fairly short order. And if that were the case and you didn't have any security interest in any after acquired property, you would no longer have a security interest in any of the inventory. Future advances. So often a debtor will arrange with a bank to have a continuing line of credit under which the debtor can borrow funds as needed. So you start out, you go in, you set up for instance, $50,000 line of credit, but you only use $5,000 of it initially. Future advances against that line of credit are subject to the properly perfected security interest in the same collateral that secured the initial loan. So, sure, you borrowed $5,000, you pay the $5,000 back, the security agreement is satisfied. There is no more security interest in any of your property. On the other hand, in the perhaps more likely scenario, you continue to borrow against it until you borrow the entire 50 grand. These future advances are going to apply there. You're adding on to your additional security interests, and it doesn't have to be the same. So you have something called cross collateralization, and credit unions are terrible about doing this, by the way. You go to a credit union and you take out a signature loan. And you think that's what it is, a signature loan. But the signature loan may very well say, in the terms of the promissory note that you're signing, that in the event that you should ever get a secured loan from the same credit union, that whatever the collateral is for your secured loan is going to cross-collateralize what was initially. And then let's say you pay off the car, and as you're paying it off, you simultaneously default on your signature loan, where you still owe $10,000. The car is paid off. The car is worth, let's say, $8,000. The credit union is going to turn around and say, okay, you just defaulted on a $10,000 loan, but your car, even though you paid off the car loan, right now is collateral for this loan. And so we're going to come and repossess your car You'll still owe us money, but you won't owe us as much because we just turned your unsecured loan into a cross-collateralized loan. You don't want to do that. So, these liens that are in proceeds or after acquired property or in connection with future advances are known as floating liens. So, for example, um, if you have inventory, it changes over time, but the lien attaches to all the inventory. It's floating on your inventory, or it's floating on a shifting stock of goods. And it doesn't matter how the collateral changes in terms of character or classification or location, because the floating lien concept allows the creditor to maintain a lien up to the total amount of their potential security interest at all times. Okay, so let's say that more than one creditor is claiming an interest in the same collateral, which can happen all the time because when a debtor starts to really go south, they will do foolish things and potentially illegal things like going out and attempting to use the same collateral on different loans. Um, so in general, the first security interest that is perfected, typically by filing a UCC-1, is going to have priority over any security interests that are perfected later. The UCC has established rules of priority in that event. Perfected security interest versus an unperfected security interest. Perfected interest is going to win. They're going to have priority over an unperfected security interest in the same collateral. If you have conflicting perfected security interests, two or more secured parties that have both perfected their security interests in the same collateral, generally speaking, it's going to be a race to record. The first to perfect or to file and subsequently perfect is going to have priority. And this is also a typical rule when it comes to things like mortgage interests, which are not governed by the UCC, but which are obviously governing a security interest. Typically, if you have that kind of conflict, the first one who gets down and records their mortgage interest is going to be the one who has priority over somebody who has not. If you have conflicting unperfected security interests, and this is where we go back to the concept of attachment. If two or more secured parties, and again, this is as between the creditor and the debtor, not as against third parties, because if you have it perfected, you don't have any rights as against third parties. But as just as creditors, and you both have unperfected security interests, generally the first one who has attached their security interest to the collateral is going to be the one who has priority. So the lesson here is always have a UCC-1 and always file the UCC-1 with the appropriate official in the jurisdiction that you're in. Okay, this is a law, so there are exceptions. There are always exceptions. So exceptions to the general priority rules include buyers in the ordinary course of business. So, provided they're buying in good faith, they will take the goods free from any security interest that has been created by the seller, even if the security interest is perfected and the buyer knows of its existence. A perfected purchase money security interest in inventory will have priority over conflicting security interest in the same inventory. That's because it was a purchase money security interest. It was the initial purchasing, notwithstanding the fact that there is a floating lien in the inventory. To maintain this priority, the holder of the purchase money security interest must notify the holder of the conflicting security interest on or before the time the debtor takes possession of the inventory. So, if you're taking a purchase money security interest in inventory, you have to check and make sure there's no UCC 1 filing with a floating lien in inventory that your purchaser has already given to a different creditor. And if you check and you see that, as long as you notify them of the fact that you are retaining a purchase money security interest in this new inventory, then you have priority over them. And then finally, buyers of farm products, chattel paper, instruments, documents, or securities are going to take those things free of any kind of security interest. And basically the idea behind most of those, certainly chattel paper, instruments, documents, and securities, although not farm products, is that those are typically things that require possession in order to secure perfect the security interest in them. And it's relatively easy to do that. You simply would have taken the securities or the documents and place them in a strong box if you were the creditor. Rights and duties of debtors and creditors. Okay, here are some information requests. A party who is considering taking a security interest is entitled by the UCC to obtain a certificate from the relevant filing office identifying all perfected financing statements on file for that debtor. Assignment and release. A secured party may, at its discretion, assign part or all of a security interest to another party, or release part or all of the collateral covered by a security interest. Amending a financing statement. A filed financing statement may be amended. The amendment must be agreed to and signed by both the debtor and the secured party. Confirmation or accounting requests. A debtor may request that the secured creditor confirm the accurate amount of the debt remaining or the collateral covering the remainder of the debt. And finally, a termination statement. When a secured debt is fully paid, the secured party generally must send a termination statement to the debtor and file a copy with the appropriate filing office. Okay, so what bad things happen to the debtor who doesn't pay his creditor? Well, default and repossession happen. If a debtor defaults or somehow breaches the terms of the security agreement, the creditor has several rights and remedies available. There's the self-help remedy. Following the debtor's default, the secured party can repossess its collateral. Secured creditor wishing to exercise its right to self-help repossession must be able to do so without trespassing, assaulting, or breaking and entering. So, typically, if you've got somebody who is not making the payments on their car loan and they foolishly leave their car out on the street, the creditor will exercise his right to self-help repossession by hiring a repo man to go and hook the car and take it away. So the wise debtor is going to park the car behind a locked fence on private property and never drive it ever again in order to prevent the self-help remedy from being utilized against him. So that failing, if that's the case, the creditor also has judicial remedies available. They can relinquish the security interest and use any judicial remedy available, such as obtaining a judgment on the underlying debt, followed by execution and levy. Execution is the implementation of a court's decree or judgment. And levy is the legal process of obtaining funds through the seizure and sale of non-exempt property, usually done after a writ of execution has been issued. The biggest problem with this is that the process tends to be expensive, unlike self-help. Once a default has occurred and the secured party has obtained possession of the collateral, the secured party can retain collateral in full or partial satisfaction of debt. With certain limitations, the secured party may retain the collateral unless it consists of consumer goods and the debtor has paid 60% or more of the purchase price or loan amount. The secured party must notify the debtor of its proposal to retain the collateral. If within 20 days after the notice is sent, the secured party receives a written objection, the secured party must sell or otherwise dispose of the collateral. The secured party also has a right to sell, lease, license, or otherwise dispose of the collateral in any commercially reasonable manner to obtain the best possible price and apply the proceeds towards satisfaction of the debt. Any sale is always subject to procedures established by state law. The secured party must notify the debtor and other specified parties in writing ahead of time about the sale and disposition of the collateral. The collateral is consumer goods. The notice must specify the method of intended disposition. Be advised that these sales generally do not produce a very good price. Okay, so what happens to the collateral once you've gotten your hands on it? Proceeds from the disposition of collateral after default on the underlying debt are distributed in the following order. First, the reasonable expenses incurred by the secured party in repossessing, storing, and reselling the collateral are paid first. Second, the balance of the debt owed to the secured party is then paid. Third, other lien holders who have made written or authenticated demands are paid. Fourth, any surplus goes to the debtor unless, see the next slide, the collateral consists of accounts, payment intangibles, promissory notes, or chattel paper, which are non-cash proceeds, in which case they get retained by the creditor until such time as they've been paid off. Deficiency judgments. After the proper disposition of the collateral, if the secured party has not collected all that the debtor still owes, the debtor normally is liable for any deficiency, and the creditor can obtain a deficiency judgment from a court to collect this amount. The debtor or other secured party can exercise a redemption right by tendering performance of all obligations secured by the collateral by paying the expenses reasonably incurred by the secured party and retaking and maintaining the collateral. And I'll note on the last slide there was a reference to notice being given to the debtor and that there has to be a commercially reasonable sale involved. Commercially reasonable doesn't mean that it's got to be like a public sale. Commercially reasonable can, in fact, be, in many cases, a private sale to a very limited number of people and still satisfy that requirement. All right, certain other kinds of creditors have other rights. So a lien is an encumbrance or a claim against property to satisfy debt and protect a claim for the payment of a debt. If a lien is obtained after another's security interest in the property is perfected, the perfected security interest has priority. But there are two exceptions to that rule. The first is a mechanic's lien, which is a non-possessory filed lien on an owner's real estate for labor, services, or materials furnished for making improvements on the realty. Thus, plumbers, roofers, electricians, Anybody who has provided materials and labor in order to improve real property has, at least in the short run, a non-possessory lien that can be filed and then foreclosed upon, notwithstanding the fact there's a protected security interest in the property, including a mortgage. An artisan's lien is a possessory lien held by a party who has made improvements and added value to the personal property of another party as security for payment for services performed. So, a car mechanic, although you think, well, he's a mechanic. Why doesn't he have a mechanic's lien? Well, we don't call it a mechanic's lien. We call it an artisan's lien because he's in possession of your vehicle. As long as he's actually in possession of your vehicle, he has an artisan's lien, which means he doesn't have to give it back to you unless you pay him. Modern statutes permit the holder of an artisan's lien to foreclose and sell the property, subject to the lien to satisfy payment of the debt. So after a certain period of time, the car mechanic who is unpaid will foreclose on his artisan's lien and sell your car in order to get himself paid. So these lien holders generally must give the property owner notice before selling the property to satisfy the lien. And every state's going to have a slightly different procedure for each one of these things. So if like self-help repossession is not adequate to satisfy debt, what else can you do? Well, you got judicial liens. When the debt is past due, the creditor can bring a legal action against the debtor to collect the debt. If they're successful, the court will award the creditor a judgment against the debtor. To ensure that a judgment will be collectible, the creditor can request that certain non-exempt property of the debtor, and interestingly enough, you'll get to that in bankruptcy as to what constitutes exempt property versus non-exempt property. And again, this differs by each state. It's very important to understand that what constitutes exempt property in one state is not necessarily going to be considered exempt property in another state. So, as I was saying, the creditor can request certain non-exempt property of the debtor be seized to satisfy the debt. A court's order to seize the debtor's non-exempt property prior to a court's final determination of a creditor's rights to the property is known as a writ of attachment. You're typically going to see these far more often in a commercial context than you are in a consumer context, because generally speaking, businesses do not have exempt assets. So the order directing the sheriff to seize and sell a debtor's property is issued after a judgment. It's referred to as a writ of execution. Writs of attachment typically have to be accompanied by very large bonds in order to make sure that the debtor is protected in the event that it turns out that there was something wrong or improper about the writ of attachment. Typical procedures for a writ of attachment are: the creditor files with the court an affidavit, a written statement made under oath stating that the debtor has failed to pay. The affidavit must indicate the statutory grounds for such attachment. The creditor must post a bond, and generally speaking, it's going to be a multiple of the amount that is owed. At least the court costs, the value of the property attached, and the value of the loss of the use of the property suffered by the debtor. I can just tell you, in Florida, it's more than that. When the court is satisfied that all the requirements have been met, it issues a writ of attachment. The writ directs the sheriff or other officer to seize the debtor's non-exempt property. And in the case of a business, that's going to be all their property. If the creditor prevails at trial, the seized property can be sold to satisfy the judgment. Garnishment. Okay, almost always going to be wages. A legal process used by a creditor to seize property of the debtor, for example, but almost always, wages, being held by a third party, by example, the debtor's employer, but almost always. Garnishment can be a prejudgment remedy requiring a hearing before a court, but is most often a post-judgment remedy. Yeah, because you're going to have an evidentiary hearing in either event. Both federal and state laws limit the amount that can be taken through garnishment proceedings. Federal law provides a framework to protect debtors from suffering unduly when paying judgment debts by setting limits on how much can be garnished per paid period. And in essence, um, most states are going to have more liberal exemptions from garnishment than the feds are. And in Florida, by and large, if you are a head of household, unless you really are making a lot of money, a head of household's wages are going to be essentially exempt from any kind of garnishment. Here's a fun fact: Creditors Composition Agreement, a contract between the debtor and his or her creditors in which the creditors agree to discharge the debts on the debtor's payment for a sum less than the amount actually owed. So, typically these would be, you've seen the advertisements, I'm sure, for folks that say that they can resolve your credit card debt for a pittance relative to what was actually owed. Bear in mind, however, that to the extent that you achieve a forgiveness of debt, whether it's through a creditor's composition agreement or otherwise, that can very well be considered to be income to you. Suretyship and a guarantee. When a third person promises to pay a debt owed by another in the event that the debtor does not pay, either a suretyship or a guarantee relationship is created. And now, what do we recall about the statute of frauds and guarantee relationships? A suretyship is an express promise by a third party, the surety, to a creditor to be primarily responsible for the debtor's obligation to the creditor. A guarantee is an express promise by a third party, the guarantor, to a creditor to be secondarily responsible for the debtor's obligation to the creditor. That is, to pay the debt if, but only if, the debtor defaults. In general, actions that release the surety and guarantee from an obligation include any material modification to the terms of the original contract without the surety's consent. A creditor surrenders the collateral to the debtor or impairs the collateral without the surety's consent, or any payment of the principal obligation by the debtor or by another person on the debtor's behalf. Generally, the surety or guarantor can also assert any of the defenses available to the principal debtor to avoid liability on the obligation of the creditor, except for the principal debtor's incapacity or bankruptcy or the statute of limitations. And here's another one of these fine flow charts that we have all come to expect and love, showing in this case the principal debtor and his relationship with the creditor and with the surety or guarantor, and a blue double-headed arrow between the creditor and the surety or guarantor. In the case of the surety, he's primarily liable to the creditor. In the case of the guarantor, he's secondarily liable to the creditor. Finally, rights of the surety and guarantor. There is a right of subrogation. That's the right of a guarantor or a surety to stand in the place of or be substituted for another party, giving the substituted party the same legal rights that the original party had. The right of reimbursement. The right of the party to be repaid for costs, expenses, or losses incurred on behalf of another. and the right of contribution. The right of a co-guarantor or a co-surety, where two or more persons are acting jointly as a surety or a guarantor, who has paid more than his proportionate share to recover the excess from his co-guarantor or co-surety. So, in other words, you still got rights against the debtor that the creditor would have had, but now you, as the surety or guarantor, are in the enviable position of having to chase down the debtor. And especially if you happen to be, say, a parent guarantor and your child student has defaulted on their debt and you have wound up having to pay for it, you really want to have to go after your own kid. Well, maybe not. Okay, that's it for the lecture portion of this. What follows is a double quiz. Gosh golly, I had a 20 question with a word bank quiz on negotiable instruments, which I was going to put in here as the last slide, and somehow I just left it on my desk. So guess what, folks? We will put that on to Friday's lecture instead of this one. All you got to do for this one is acknowledge that you listened to it. And if we have a quiz on this, it won't be before Monday. Ta-ta.